Hi everyone, in this video, we are going to discuss about the partnership of law. I'm NURUL HIDAYAH. I'm going to present about the introduction of partnership law, elements, nature, and rules for determining the existence of a partnership. A partnership is an arrangement between two or more people to oversee business operations and share its profit and liabilities. There are few elements in the partnership. The first one is the association of persons. And the second element is the persons must be carrying on the business. The third element is carried on in common. Last but not least is the with a view of profit. Next is the nature of the partnership, which is defined under Section 3, Subsection 1 of the Partnership Act 1961. Next is the two or more persons or agreement and also the sharing of profit. This can be illustrated in the case of Alagappa Chettiar against Coliseum Cafe. And there are few rules for determining the existence of a partnership. The first one is the Section 4, Subsection A, joint ownership or tenancy. The second one is Section 4, Subsection B, sharing of gross returns. And the third one is Section 4C, sharing of profit.
Hello everyone, this is Kirthana Maran. In this part, we are going to discuss about specific consideration affecting existing of partnership, relationship of partners and third parties, liability of partners, and also type of partners. Specific consideration affecting existence of partnership. Section 4, Subsection C1, payment of debt by installment. A person receives payment from the profit of a business is not a partner when he gives loan for that purpose of business. A creditor getting back from his loan from the partner of the debtor's business does not make him a partner. Example situation: a need to start a business and apply for a loan. Creditor has loaned some money to A. A pay back the loan using profit from his business. Even though the creditor received profit from A's business, they are not partners. In the case of Batley against Conciliated Bank, the plaintiff had borrowed certain amount of money from defendant to construct a railway project. In order to secure the loan, a charge was created. Further, D will charge 10% interest and 10% net profit derived from the project. It was held that P and D are not partners, even though D is entitled for the net profit for the business. Section 4, Subsection C2, remuneration. Example situation: A employ B and pay the salary. If B brings project to A's company, B will be receive commission from the net profit of the project. Any payment or commission to B under any arrangement does not make him partners to the partnership. However, salary partner is valid so long that it is expressly stated in the partnership agreement as stated Section 26 of Partnership Act. In the case law of Chua Ka Seng against Bonchai Songkolong, it was held that the court decided that the person is not a partner even though he receives salary, as there is no clear provision in the agreement. the dependent of the deceased partner may. The dependent of the deceased partner may receive a portion of the profit from the partnership, but it does not make them a partner in the partnership. In the case law of IRC against Labus trustee, the fact of the case is the deceased had left a will to give a share and profit in the partnership to his wife. Later, the government has imposed tax to the wife on the ground that she is a partner in the partnership. The court held that she is not entitled to pay the tax even though she receives share and profit as she is not a partner in the partnership. Section 4, Subsection C for payment of loan or interest out of loan. A person who gives advance to any person or firm who is about to start a business and later receive profits from the business does not make him a partner. In the case law of Ray Young ex parte Jones, Lyot has given Young a loan for $500. Based on the agreement agreed by both parties, Lyot will be received $3 per week from Young. Lyot will assist in the management of the partnership and was given a chance to enter the partnership within 7 months from the agreement. Nevertheless, he refused to join the partnership. It was held that Lyot is not a partner as he refused to join in. Section 4, Subsection C5, Sale of Goodwill. Example situation: A sell his business to B. When he do this, he is not only selling his business, but he is also selling the reputation of the business to B. If A receive profit from the goodwill, this will not make him partner to B. In the case law of Pratt against Drake, the fact of the case is a man sold his practice and goodwill to another professional man. In the agreement, it was agreed that he will continue to receive profit. The court held that the man was not a partner. Next, we will go through the relationship of partners and the third parties. Section 7 stated that all acts done by a partner bind another. The first one, purpose of the business of the partnership. The second one, firm's ordinary course of business. The third one is done by the partner as a partner. The purpose of the business of the partnership. In the case law of Chan King Yu against Lee and Wong, Lee borrowed money from his wife for 35,000. He then issued a receipt to acknowledge that he has received the money on behalf of the partnership. When the partnership refused to pay back the money borrowed, the wife then sues the partnership. The court held that since the money was used to pay the debt of the partnership is therefore liable to pay the wife the borrowed money. The firm's ordinary course of business. In the case law of mercantile credit against Garrett, there are two partners in a partnership, Parkin and Garrett, where Garrett was a sleeping partner. The nature of the business partnership was to provide garage and repairing car. One day, Parkin, without the authority from Garrett, sold a car which was not belong to them to the plaintiff for $700. Then the plaintiff then sued Garrett and the partnership as Parkin did not have the right to sell the car. The court stated that action succeeded as the act of selling the car is the usual way of business. Next is done by the partner as a partner. In the case law of Free Bricks and Car ex parte right, a two-partner firm of father and son were being pressed by a creditor. The son agreed to assign the book debts, money owed to the firm, to the creditor in order to play for time. The father knew nothing of this. The deed of assignment stated that it was to be made between RB Briggs and HR Briggs, trading under the style of firm, a style of firm of Briggs and Co. But the father's name was forged by the son. The question arose as to whether the father was liable on this deed, and the court held that the court applied an equivalent to Section 8 of FA 1961 in a manner showing intention to bind the firm and executed by the partner. Liability of partners, contractual section 11, tortious section 12, criminal not jointly liable, holding out not authorized. There are four types of partners. The first one is active. An active partner is also known as ostensible partner. As the name suggests, he takes active participation in the firm and running of the business. He carries on the daily business on behalf of all the partners. This means he acts as an agent of all the other partners on a day-to-day basis and with regards to all ordinary business on the firm. The second is dormant partner. This is a partner that does not participate in the daily functioning of the partnership firm. For example, he does not take an active part in the daily activities of the firm. He is, however, bound by the action of all the other partners. The third one is quasi. A quasi partner is a partner who, after retiring from the partnership business, lends his cash to the firm and earns interest based on profits. He is someone who has ceased to be a member of firm but has retained his or her share capital. He is not a shareholder in the company's profit or losses. The fourth type is salaried. Salaried partner who poses as a partner and earns a salary payment. He may be a mere employee or he could be a genuine partner. This means that a salaried partner is a partner who is accountable for a portion of the company's profit but is also paid a regular income in exchange for his or her assistance in the firm. In the case law of Chua Ka Seng against Bonchai Sompol Pong 1993, the defendant was formerly a partner in an architect firm called RSP, and the plaintiff was only a mere employee in that firm. The defendant then resigned from RSP and another architect firm was established by him, namely CKS. The defendant asked the plaintiff to cease working for RSP and offered the plaintiff to work with him at CKS. The plaintiff claimed that both of them agreed in the contract that the plaintiff will be the partner who had the right to 20% of the net profits. The defendant conversely said that the plaintiff was a mere salaried partner and who was entitled to be paid 20% of profit, including salary and bonus. It was held that the plaintiff was merely a salaried partner paid by 20% of the net profits, including salary and also bonus. Thank you. My friend Jayanitha will be explaining the next part of the partnership law.
Hi everyone, I'm Jayanitha Arumugam. So next, I'm going to present about the capacity of partners, partnership agreement, illegal partnership, effect of illegality and dissolution in the partnership. The first one is the capacity of partners. According to Section 11 of Contract Act states that a person is considered as having the full capacity to enter into a contract if he is of the age of majority, sound mind, and also not disqualified from contracting by any law which he is subject. This can be illustrated in the case of William Jacks, where Young was also liable as a partner of the firm, even though he had not taken any steps to repudiate the partnership after attaining the age of majority. Next is the partnership agreement. It may exist either in writing or oral. Partnership contract normally stipulates such the firm's name was, parties to the agreement, types of business, duration of partnership property, management of business, amount capital, and dissolution of partnership. Next, an agreement may be void due to propose to carry on an unlawful business in an illegal manner, and a partnership is also void if it has a membership exceeding 20. If a partnership is illegal by reason of purpose, the court will not recognize it or make any order in respect of it which relates to matter as between the parties to the illegal arrangement. Next, I'm going to discuss about the dissolution of the partnership. Based on without court's intervention, the first one is by agreement and the second one is the by operation of law, which divided into three: Section 34, Subsection 1, Subsection A, Subsection B, and also Subsection C. The third one is by death or bankruptcy, and the fourth one is by charging on share. Last but not least is the by supervening illegality as stated in Section 36 of Partnership Act 1961. According to the court's intervention, the first one is the mental infirmity, secondly, permanently incapacity, the third one is the conduct prejudicial to the partnership business. Fourthly is the persistent breaches, fifth one is the loss-making business, and last but not least for the court's intervention is the just and equitable ground. In conclusion, the advantage of setting up a business in partnership is the higher volume of capital than sole trader. Hence, less procedure is required to set up a partnership firm than a company. And that's all from us. Thank you very much.